Welcome to our second live event of our web series featuring Ask Me Anything sessions with key mentors, partners, and advisors from our OTL network. In each session, we'll delve into important topics for early stage entrepreneurs, offering advice, real insights, and personal experiences to help entrepreneurs on their startup journey. Today, we'll be featuring Cheung and Phyllis Wong, corporate lawyers from Oldham, Lee & Nye, specializing in startups, venture capital, and cross-border transactions. They will be discussing with us how to structure healthy co-founding agreements, share vesting terms, and other startup-related legal matters. Please stay tuned until the end because we'll be offering a discount, and also don't be afraid to ask questions in the chat box for our speakers. So Charmaine,
Yes.
Starting a company is very exciting. There's a company vision, a pitch deck, a team, or maybe even just a few co-founders. So they decide they're both in it to win it. And perhaps they should split the equity 50-50 right away. Is this a good idea?
Yeah, like nowadays, many people, they are very excited with new ideas. They will be forming teams, they will be working together to be innovative, disruptive, right? But usually, in my experience, a lot of the time, they would be neglecting how to structure their relationship. I would call this relationship. Let's not use the term shareholding structuring, like it sounds so legal. But at the end of the day, it's a human relationship between the people, right? So if you're asking me, it can be 50-50. Usually it would be 1/3, 1/3, 1/3. So you see, the statement behind is that, oh, we are all equal, right?
Yeah, definitely.
But then in most cases, we all know it's hard to be equal. Maybe somehow in a way you are contributing a bit more on the knowledge side. Maybe I'm contributing a little bit more on the money side. So I think all the founders, they should be very realistic on what they're actually contributing and how to value what they are contributing. So as the basis to create the initial shareholding structure. However, in most cases, a lot of the people, they would be focusing on, oh, my ideas, oh, the prototypes. It's time to get the investors. But they would have totally neglected that actually they need to talk about their relationship. Just like any couple, or even it's like dating, they need to mention how we are going to work on that.
Yeah, definitely. I think those are some challenging questions to really consider up front. So let's say a startup really wanted to try and structure this early on.
Yeah.
And maybe there are some good stories, some bad stories based on your personal experiences. Do you have any stories you can share of maybe how startups have succeeded or failed due to how they were structured?
As you know, as the solicitor, we are up for the strictest confidentiality obligations. So we could not be naming any particular story. Why don't I let Phyllis share with us a sort of a famous story in China about an internet brand, internet startup, which somehow turned into an F&B business, and what happened to them.
Wow. Okay.
Yes,
take it away.
Sure. So three young men, they met in university. So I just call them A, B, and C.
Okay.
So they are university friends. So as Charmaine just mentioned, so in 2012, they started off with an internet business, but it didn't go well and failed. And then in 2013, they started an F&B business selling a Chinese style bun, a
sandwich, hamburger, whatever you call it. So in Mandarin, it's momo. I think it's momo or mopo, or something like that.
Yeah, so
delicious.
Should be, because they the business turned out to be very well, as they have the internet startup experience. They know how to attract the people. They know how to market themselves. So the business went on really, really well.
Yeah, so that initial shareholding is like 40%, 30%, and 30%. And then when they have great successful internet promoting, and then the business really went very well, and then they have attracted an investment of RMB 40 million. And then at the same time, there is a new co-founder, I would call him D, joined the company. Then all the founders, so they agreed to kick out B, one of the original founders, and then offering him to buy out his shares of 30% with a cost of RMB 270,000. And then this B, they then commenced another business, and which is competing directly with the original F&B business, and then they sued to the court in 2015.
This is very classic, you see. Like at first, like when they join in to set up the business, they did not talk about, oh, what are you actually contributing? Right. What are you going to do in the long run? Because when you're running a business, It's not the. This is a very important concept. I hope every of you would remember. It's a dynamic process.
Yes.
We won't stay as in basis forever, right? Things may change. Maybe somehow, like she would be dedicating more, then she should be actually getting more reward. But in a lot of the founders, they would fix their shareholding structure, and they have forgotten, like not mentioning that in the initially they should be talking about how to value our contribution. But in the ongoing process, they also forget to measure the input and also the underperformance.
Right.
And what's going to happen is that it would accumulate the satisfaction among each other.
Yes.
So I would be so unhappy with what's going on, right? So in that case, when you could imagine if you are B, you are offered, when you know that the company is going to be invested at a valuation of 40 million renminbi, and you are only being offered 270,000.
Yeah.
How would you feel?
I'd feel very disappointed. All the time, effort, energy, and at the beginning, having this agreement already made to then be sidelined, pushed away. I sort of understand emotionally why he wanted to start a competing business. But these things are very common. I think we all know that a lot of startups fail because of, co-founders, disagreements. And as you said, things can change over time. Business strategies, business direction, all of that can change. So I think what we all might forget is how to structure the agreement initially healthily, because we only think about it in terms of share vesting for maybe employees or share vesting for other related people, stakeholders. But we never think, because I'm your friend and we're starting a business together, we're in it to win it.
Exactly. So that's the misconception. We somehow we are too confident in the relationship between each other. So we have been forgetting how to define. Oh, what if something happened? How to solve it? So this is a very important concept. I hope everyone here who is on the live streaming would remember this. At the end of the day, it's so easy for you to Google templates, founders agreement, whatever, on the internet, right? You look at it, you would be seeing those terms: vesting, tag along, track along, transfer restrictions, right? Those, but actually, a lot of us may not be that familiar with what the terms are actually about. But you think that we need those terms. But what's more important is the logic behind, which is how we are going to define our relationship. Initially, what are the contributions? Ongoing, how to measure one's contribution, how we are going to make decision. At the end, if things don't turn out right, how we are going to solve it. So those are like human relationship questions that you will be asking between husband and wife, mother and kid, any relationship. Don't just think that, oh, as you said just now, oh, we are so close. We have been uni friends since 2000 and oh, then I would be disclosing my age. I should stop it. You see, but no, things would change. Things would change, and especially you're running a business together. The passion is there, and we all have the need to be felt that actually I'm being respected. It's not only about the friendship is gone, but it's also a feeling that you don't respect.
Yes.
Right. So I hope when you are trying to next time Google a founders agreement, you would do this. I would try to talk about it later on, like as we move on.
Yeah.
But how you should be having the line of thoughts when you're designing your own structure.
I think that's actually my next question. I think now we know it's so valuable to really consider healthy co-founding agreements and structures. What's some advice that you can share on how a company can create a sustainable shareholding structure among co-founders or other existing shareholders?
First of all, I think everyone should remember actually, I should say you should have the clear understanding on actually what are shares. Okay. So number one, share is a scarce resources. It would just keep on being diluted. So once you give out the shares, you need to think about, okay, I'm giving you the shares. Is there any right I can take it back in case things don't go on well?
Mhm.
Also, if you are not working so well, is there any way that I can adjust? Or if you are doing very well, how can I give you more?
Yeah.
So I have so many clients that they think that ESOP is a very safe term.
Yes. Yeah.
And oh, there are advisors, there are key consultants. I need to reward them, but at that time, oh, look at the pocket, I don't have enough money. So the way that they always think about is that, oh, I would reward by share, whether it's option or it's restricted shares, right? Yes, you need to think about whether those people, they would be seeing the same thing with you, which means whether they are thinking that those shares would have an increment of value,
Right.
whether they are willing to contribute in the process in adding in value to those shares. It's not like, oh, this consultant, he is going to introduce me to some leads in the upcoming 3 months, then I give you 5%.
Right.
Because you're going to dilute yourself by 5%, right?
Yep.
So you need to remember that this is scarce resources, is going to be diluted. And you also need to remember the feature of your shares. First, of course, it has the economic benefits in it.
Mhm.
It's the dividend. Also, in the long run, we are talking about if things go on right, then there should be an increment of the value of the share. So there would be an exit value.
Yes.
At the same time, there's actually voting rights
Yes.
in the shares. Do you want every single one that is holding your shares have the voting rights? Of course, we would be coming to a lot of technicalities here. Oh, he's only a 1% shareholder. Does it mean that, oh, he can do something to be detrimental to the company? In case he doesn't approve a resolution, what's going to happen? I do not plan to go that deep today.
Yeah.
But it's a very key question, whether you're willing to share some say in the company with the people who are holding your shares.
Yeah.
So coming back, if you think about this way, then you know that every time when I'm giving out the shares, I should be extra cautious. I would only be giving out to people who believe in the vision, who believe in the dream that we're going to build together.
Yeah.
Also, at the same time, this structure should be giving the recipients the feeling that it's a fair system. It's a predictable system.
Mm.
I am contributing. Actually, when you are saying that I'm giving you the shares, it's an exchange. Right now, I cannot be giving you that cash. Later, I'll be giving you more. So this time, maybe I exchange it, shares with you, right? But then you need to think about whether those person is ongoing contributing value as the recipient of the shares,
Right.
and the perception of the recipients. That's very key. Some people, a lot of my clients, they were, oh, as I said, ESOP, like everyone is talking about ESOP, I'll be giving shares to the employees. But they forget to think about how the employees would be perceiving the shares.
Yeah.
A lot of them may feel quite indifferent. There are a lot of factors in this reaction.
Do I want money now? Do I want shares? Trade-offs?
Do I see any I don't see any value in the shares.
Sure.
Why are you giving me? Or they look at the shares, oh, only 100 shares, but it's 1 cent each.
Yeah.
Why? Oh, look at the shares. Do you want me to work for you forever and ever?
Right.
So there are can be a lot of misunderstanding, misconception. So when creating a shareholding structure, of course, you need the right clauses. Like clauses is the end. I should not be talking about it. You need the right design.
Mhm.
You need the some forecast, but you need open communication.
Okay.
Then you incorporate everything on a document.
Okay. Great. Well, I think that moves me on to my next question. What is then a good way to structure that? What is share vesting? What is ESOP, as you mentioned earlier? And why should one do it? And is it legal to have a pool of shares, for example, unassigned at the beginning?
I think I keep on repeating myself here, so I hope the audience here could bear with me. But it's very essential. You need to shift your mindset whenever you're going to structure your shareholding structure. You need to have a couple steps. It's not just oh, I Google, I get the template, I fill that in, then I'm protected. Please leave this thoughts away. What you need to do is that first, I suggest that the co-founders, they should really sit together, have an open communication, talk about at this point of time, when we look at this project, what are you contributing? What am I contributing? At the initial stage, there could be family and friends investor or angel investor, very early stage. They would be just giving in money, potentially some connections. At this stage, usually a lot of the founders would think that, oh, money is king because I need the money to kick off my project, right? But actually it's not, because money would depreciate as the value of the company goes up. So the founders should think through the logic, how we are valuing the money, how we are valuing the knowledge, how we are valuing the time that one is contributing. For example, if I'm going to work full time, you are going to work half time. Does it make sense if we have equal share of shares?
No, I mean, for me, it would be great, but for everyone involved, probably not.
Yeah, but a lot of the founders, co-founders, at this point of time, they may be too shy to talk about. Maybe I'll be thinking, oh, you have a family, you still work part-time, you still work part-time here, and you're an expert in this area. And how would I be feeling okay to ask you, can you reduce your shareholding? Let me take more. I feel too shy, too embarrassed.
Right.
Yeah. But if at this initial communication, you could not be having an open chat, then when you expect that there could be one.
Okay.
So initially, we should sit down, assuming that we are the co-founders.
Yes.
We should sit down. We should be talking about what you're giving, what I'm giving, what she's giving, potentially who we would need to set up, and initially who would be having more say, or to be exact, like on whatever topic, who would be have whatever say. But that comes to the management part. We can talk about it later.
Okay.
Then on the structure, we move on to ongoing. Oh, what's the expectation? What's your expectation over me? What my expectation over you? Say, for example, nowadays, many Hong Kong people are planning to move to somewhere else to relocate, immigration. What if one of the co-founders leave for somewhere else? Then should she or he be still getting that much shares? Is there any mechanism for adjusting?
Yes.
Adjusting the shareholding. So this is from the communication, we move to the actual action that would reflect the discussion outcome. Then you should gather all those and put it together and try to keep it in a document. Of course, on the document there could be other clauses.
Yeah.
Other key points that we can talk about. But I hope everyone, when you are looking at the shareholding structure again, I'm sure, like if you have been, like there have been some friends staying here listening to us, you may have already some bubbles in your head. Oh, I'm already in some chaos, maybe some problems.
Need some help.
maybe it's normal,
Yeah.
but please have a second thought over this and think about how you should be dealing with it.
Okay. So I think the takeaway there, at least for me, would have been try to have some of these difficult conversations or upfront at the beginning. Try to outline clauses and structures kind of as a general agreement for everyone involved. Just if anything were to arise in the future, you can have all these bases covered. But it sounds like we'd need an expert, much like the two of you, to help guide us, because these are all foreseen circumstances that only experience could really help dictate and help us really understand what potential eventualities do we need to be protecting ourselves or outlining clauses for. So I think this is very interesting things for us to definitely seriously consider.
It's actually quite similar to getting a prenup signed.
Yeah.
You have heard about a prenup, right? Like,
Yeah.
we get married. Before we get married, we will be setting out in case we separate how we're going to allocate our assets. But for co-founders agreement, it's actually one more step more than setting out how we separate, because you do not want to separate, right?
Yeah.
So in addition to that, just imagine it's like husband and wife talking about, oh, the husband would be the major breadwinner. You would be at least contributing your weekends to the kids. For the chores, the wife would take care. Managing the helper, the wife would take care. But we agree that every now and then we will spend how much time together, or on anniversary, what you are going to do for me, things like this. So it's similar to co-founders agreement as well. So it talks about decision making process. Honestly, in the a lot of the template co-founders agreement, they may not be talking about the decision-making process, or it would be quite rough clause saying that, oh, only how many % of the shareholders agree, then a couple issues can be approved. But actually, we can be more detailed with this. Say, for example, I am the CEO, you are the CTO. So maybe whatever there is any partnership in relation to IT, if we could not be agreeing on each other, you would be the one having the final say. Or on particular fundraising issues, maybe there are a couple of investors, very lucky situation, right? You do not know which one should be the lead, and there are some argument because one investor is having a strategic value, the other is giving better money. Then we would say, oh, in this case, maybe any two co-founders agree, we could have this issue solved. But a lot of the founders, I mean, Rohini, you should have been meeting quite a lot of the co-founders, and you may have been listening to stories about how they do not get along with each other. It's actually from this type of things, maybe even smaller things. Oh, whether we should be hiring someone like him, whether we should be tapping into that market, you see? And then because there has been no mechanism on dealing with stuff like this, then the misunderstanding started to accumulate.
Yeah.
To a point that, oh, we feel that we could not be working together, then I may just disappear, holding the shares. Right? So the next point is, many cases are like this. You will be knowing that, oh, there could be one co-founder holding the shares and then disappear. But there are actually ways to prevent. So Phyllis, can you talk about what are the ways that we can prevent this kind of situation?
Investing or
what clauses we could have in an agreement to prevent a co-founder leaving without returning the shares?
Okay. So well, in these cases, there may be some buyback provisions in the agreement. So saying that, like, okay, if you are leaving and then the other co-founders if you're leaving within like the first 3 years from the commitment, then the other co-founders may buy back your shares at a discounted price, so that and then you're like compulsory to sell the shares to the other co-founders. And then in this way, then we will not have the situations where the founder leaving but still holding like a 30% of shares but not contributing to the company anymore.
So it means that in the very beginning we could agree on we could agree on if one wants to leave the venture, then there would be a buyback mechanism.
Yeah.
And to facilitate the buyback mechanism, some documents can be signed ahead. And everyone at that point of time, actually it's the easiest timing to have that signed because it's the honeymoon stage.
Yes, I'll sign anywhere.
Yes. Oh,
Take
I will close my eyes. I will sign.
sign.
This is the honeymoon stage that
Right.
you can get things signed and you can get things prepared. Once the relationship has been sour, everyone would be so alert.
Yeah.
No one would be willing to sign anything and to give out anything. And not because that they want to kill the venture, maybe just because of some personal emotion, some revenge is working here. Then I would just trying to be very difficult. You see, it's
Yes.
not getting logical here.
Yeah.
So it's a situation that one should avoid.
Mm-hmm.
And I could also come back to a point that you mentioned just now about vesting.
Yeah. Yep.
So we all know, like
Perfect.
vesting is it can be quite standard. Do you
Yes.
know the standard?
Yeah. 4-year with a 1-year cliff. Yeah. 4 years.
And then the 3-year, usually like in a very typical situation, it would be a 36-month vesting month by month, right? It sounds very typical, very right, and it's easily accepted by most people because it's so standard.
Yes.
But there is one thing, if a pure vesting clause that don't cater is that what if someone who is on a vesting time, yes, he or she is, but she's not performing. She's just sitting there, not really working, but you cannot say that she has left her role. But her shares would continue to be vested. So that's something that you don't want.
Mm-hmm.
Then you may need to consider whether each co-founders there should be some performance pledge.
Yeah.
But of course, we come to another difficult question, like how to measure.
Yeah.
Like KPI, like key performance indicators, to me somehow it's a grand term, but it's imposes practical difficulty as well. We don't know what means by good, what means by bad. But then I'm sure with the smart brains sitting together, there could be reasonable standards to be set up. And this is key because you want to see the company growing. You want to see everyone is performing their expectation, right?
Yes.
So why don't you, instead of just having a pure vesting clause, some performance indicators may be needed as well.
Okay. Yeah, I think that's very helpful to understand then all those terms agreed upon up front, so everyone has something to measure by moving forward as the company grows.
Yeah, so it's a open communication on the initial contribution,
Mm-hmm.
how to value each other's ongoing contribution, and what's the mechanism of adjusting the shares. In Cantonese, we hope that the co-founders agreement would offer a 好來好去 solution, like a
Whole long, very long, very good solution.
Yeah, we are harmonious when we stay together, but when we depart, it's also in a cool style. It's not like we would turn everything so sour, so dramatic and ugly.
Okay.
Yeah.
Yeah, that's a great philosophy to consider when structuring the agreements.
Yeah, because the agreement itself, it's just a piece of paper. It's cold, but we are talking about human relationship here.
Yeah.
So you need some human elements in it to make it a lively one that would be helpful when there are things, there are situations that the co-founders could not handle. Like there are funny cases that some of my clients, they sign a co-founders agreement. Of course, they smart enough, they go online, they got a template, they think, oh, it's actually something that readable. If you have read our some of our agreements, it's so easy to be up to 70 pages, a large chunks of words with no comma or full stop. Challenging. So
Oh,
they
wow.
found something that they can read, and they
Yeah.
think, oh, let's sign it. Yeah, we are so sophisticated. We have got this done already, right?
Well,
So they signed it. But then, as I said, they had no communication when they signed, and they because of that, a lot of misunderstanding and bad emotions accumulate. So they fought with each other, and she left. Then I was looking at the agreement. Oh, actually, nothing's mentioned there.
Oh no.
Oh, how can I like you? Then they would be looking at. Oh, is there any non-compete clause? Oh, there is one. Oh, does that fit? Or I would be having another very standard question is that, oh, can I dilute her? Can I be issuing more shares to dilute her, right? Then I would be looking at that. Actually, when you sign that, you think about it. Mostly, the answer is no.
Right.
So, and at that point of time, usually there could be investors wanting to invest. What do you think the investor would react?
Where is this co-founder and why do they own so many shares?
Yes, and then there would be a large sense of suspicion and a trust issue because I'm investing in a company. Potentially there could be dispute.
Yes.
And maybe she was the CTO. What if she's setting up a competing business or taking out the intellectual property?
Yep.
Or she's the marketing lead. Oh, what if she contacts all the customers? So you are creating questions for the investors to ask you that you cannot really answer so well.
Right. Right.
Yeah.
And then it would be hard to raise funds.
Very hard, very hard. Then you will be looking at the company's dying.
Right.
You see, and you spend quite some time on that. It doesn't worth it. If we look into some survey a couple of years ago, in the US, actually 62% of the startup they fail because of founder dispute.
Right.
Shareholding structuring. And ironically, a lot of the people when they are starting their business, they not mentioning the tech startups or a lot of most of the members of Ooosh, we just talk about any restaurants you could see on the road or any boutique selling clothes on the road.
Yeah.
Maybe just 2-3 people, they want to do something together. They don't need any investor, but still they are facing similar issues. So I hope that's why this is one of I told you just now, this is my favorite topic.
Yeah.
Out of all, because I really hope that whoever try to spend the lunchtime with us listening would there would be 1 or 2 statements that would be alerting you, trying to think this in a different way.
Yeah, thank you so much. I think this has been very insightful to really understanding the importance of all of those points that you shared, open communication, discussing things up front, making sure everyone is protected.
Yeah.
Not just yourself. So moving on to other shareholding type of structures or other agreements that you might have with maybe potential investors, what is a SAFE? Can you explain that to us?
Sure.
Yeah.
So SAFE is it's a simple agreement for future future equity. Yeah. It's been it's actually a product that is has been quite popular in these years, especially first it started of course in Silicon Valley from the Y Combinator. I think it should be
popularized.
Yeah. It's because the founder in very early stage, the investors have some confidence in the company, but they want to move things fast. So instead of doing the lengthy standard equity investment procedures, which means assigning the term sheets, doing the due diligence, the legal due diligence, the financial due diligence, whatever. And because for a startup, actually at that stage, not many things you can see, right? So instead of spending all the time and money on doing all this, I would be just committing you a certain amount of investment. The company, the startup would be committing for future issuance of shares when, in most cases, it should be when there is a future round of fundraising,
yeah,
either at a valuation cap or at the discount,
yeah,
or both. Like there are different ways on working those. So it supposedly it's a very short document, not 70 pages,
Right.
only 4 or 5 pages, summarizing all these terms. The pros and cons. Let's talk about the pros and cons.
Perfect. Yeah.
Yeah. So on the pros, it's short, it's easy to understand, right? It saves time, right? And on the cons, I think it's always good to check with the auditor about the nature of this funding, whether it should be counted as debt or equity.
Yeah.
But it should not be an issue now because there are many startups issuing this. And for the I think is that because this has been getting popular in Hong Kong, but still a lot of the investors, especially if they have not been really very into the startup scene, they may not be that familiar with this instrument. So they may be creating or inventing very special clauses
Okay.
into it,
Yeah.
which would defeat the original purpose of having SAFE signed.
Mhm.
So, but I recently, the clients that I've been dealing with, they have been facing issues like this, but at the end, the SAFE are signed, and they get the money to help grow the business. So, which is not a bad thing.
Yeah, no, I think that is great. It's good that there's more awareness about it and people are utilizing this to easily onboard new investors.
Yes, and usually for SAFE, it should be very simple. Like there should only be a couple of terms. So, Phyllis, can you share with us what terms that we may have on a SAFE?
Well, let me think about it. Okay, well, in the SAFE, then there can be some terms is on like when will the shares be issued. So the shares will usually be issued when there is a next round of equity financing, and then because the investor is signing a SAFE, so he's like an early investor as compared to the investor joining the company at the next round of equity financing. So usually they would be entitled to some kind of discount at the valuation in the next round of financing. So but actually the SAFE is actually a very like the name of it is a very simple agreement. So there will be not as compared to the subscription agreement in the next round of equity financings, then there will not be such a long provisions of warranties, representations. So mostly it would be like just setting out the scenarios when will the SAFE be converted into the shares.
Yeah, the financial parameters is the key on what's the discount and what's the valuation cap. It's subject to argument. And there would be also clauses on liquidity event. What about if the company is there is a trade sale that the company would be bought out? Then what's going to happen? And there would also be clauses on conversion, how the SAFE would be converted. There would be some short but key reps and warranties. And I suggest that everyone should still be careful with even the Y Combinator's reps and warranties, because it's very key on the IP or on the standing of the business, right? So you need to make sure that every single statement is correct. Otherwise, the startup or the founders may be claimed that they have breached those warranties.
Right.
And also, there is an important feature is that it's stated so clearly that the SAFE holder has no voting rights.
That was my next question.
Yeah, that's the key, because at that point of time, even they are an investor, but the nature of SAFE is to make things quick.
Yes.
You do not want to get into the lengthy discussion on what matters should be counted as reserve matter, or whether you would be having a board seat or a observer seat.
Right.
So they should this is the original purpose. So that's why they should not be having any voting rights or any board seat. But there are still investors in Hong Kong. They may be requesting clauses like this. So the founders are, of course, you need the money, right? But at the same time, you need to think about the long-term implication. What if what if they are not a very good investor in a way that they would be causing disruptions on the operation of the company? So how you're going to negotiate on that? So that can be tricky, but we can help handle, of course. And also, one point is that nowadays, like the startup in Hong Kong, at first when they are kicking off the venture, usually they would be using a Hong Kong company as the entity. Once there is equity investment, they may consider that they need to restructure their company by setting up an offshore entity, be it a Cayman or BVI entity, to hold the Hong Kong entity, which can be an operating entity, right?
Yeah.
It's a good idea because you would be segregating the holding structure and the operation level. Yet in the Y Combinator SAFE, because it's applicable for US companies, there are some wordings on reorganization, whatever, but still it's not on spots on some local Hong Kong issues and the restructuring that I mentioned just now.
Right.
So that's why I'm planning to tailor-make a SAFE governed by Hong Kong law, catering for Hong Kong companies.
Wonderful.
Yeah, and I also hope to make it in Chinese as well, so a bilingual version.
Perfect. And we can discuss closer to the end where maybe some of our viewers can find those draft documents.
Still need some time, but this is in my plan. Definitely, I'll be doing that because a lot of my clients, they would be adopting the Y Combinator SAFE.
Yeah.
It's quite standard. Like everyone is using that. Exactly. But if you take a closer look, of course, it's a well-drafted document, right? But still, the US elements, they may not be applicable to the Hong Kong company situation, and it can create confusion and issues. That's why I hope I can do something like this.
Perfect. Thank you. I think that would be very good for the community. I did want to ask, say with the structure of a SAFE, given that shares are not immediately allotted to investors, are they still considered shareholders and are they protected by the governing law, the company laws?
Not really, because they are not shareholders. So under the company's ordinance, they would not be having the rights of a shareholder. But as I said just now, depending on how the entry of the auditor would be made on the SAFE, so somehow they may be a creditor. They can be a creditor of the company. So they may be having some unsecured creditor protection with regards to legal protection. But before conversion, they should not be considered as a shareholder. And that's why they would not be having any voting rights. But somehow there could be clauses in the SAFE that saying that, oh, if the company is going to pay dividend, then they should be having a share. But even like this, they are still not shareholders.
Understood. Okay. And one last question about maybe term sheets.
Okay.
How should entrepreneurs deal with a term sheet when they receive one?
First of all, I always suggest founder to look for more term sheets if they can. So it's good to do some comparison, right? And then when you receive a term sheet, it's an advertising time, maybe you should look for a lawyer to look at that to make sure that you understand all those terms in a precise way, in the accurate way. Like there could be terms on you think that you understand how it works, but actually because a term sheet, it's meant to be a brief document, right? So there is no details in it. So there are details that a founder should be considering. Say, for example, there is always a clause on drag along. Drag along, it means that, in case that the majority shareholders want to sell their shares, you as the minority shareholder, I can require you to sell together with us so that we can be achieving a trade sale. 100% of the shares would be sold, right? Then you need to be considering very carefully how to define majority shareholders. whether the founder wants to lead because it's apparently it's an exit opportunity
Yeah,
for the
definitely.
founder, right? But a lot of the time, they don't know how this term is going to be interpreted. Then they just leave it the drafting as it is, and creating them that having no say on such an important event. But there are drafting ways that can help founders achieve this purpose. And in our experience, a lot of times our drafting work, the investors, they commercially they would agree on such term. So don't just think that it's a template again. Like no agreement should, like, of course, they look very similar to each other, but in each particular situation, there could be tailor-made points. That's why I think, and a lawyer should not be charging you too much on reviewing term sheets.
Okay.
Yeah, in our case, we usually combine the term sheet review together with the fees when the transactions really take place.
Okay.
So it's always a good idea to get a founder. No, to get a lawyer, not a founder. I'm a founder of myself, but I'm also a lawyer to review the term sheet for you, to explain to you, and to set out the negotiation strategies.
So lastly, would you like to talk to us a little bit about your online platform that OLN offers, as well as the associated services, of course?
So it's a very exciting platform. We want to help any companies, not just restricting to startup, to have a reach to agreements that they may be using on day-to-day basis. At least they could locate the right documents by just clicking in some details. And Phyllis can tell us what kind of agreements that we have on OLN Online.
Well, yeah, OLN Online is actually an online legal solution platform. So as Cheung said, there are a lot of vast variety of template agreements there. So, for example, from business setting up, like a founders agreement, or some even a pre-incorporation agreement, and then to investment agreement, to save, for example, like save,
and employee issues.
Yes,
too, right?
and then from the daily business operations, like service agreement, terms of use on the website, or privacy policy, and employment agreement. So there is just some all the basic needs for startups and SMEs, and then you will find the agreements here. So like you may wonder, like, what's the difference between like Google Online, so founders agreement template free? So what's the difference between like OLN Online and the templates that like Google Online? So the difference is that like on OLN Online there is a step-by-step approach, and then you can click and then you can choose what are the options suitable for your company. So so it will be like a tailor-made agreements for you. And then also under the OLN Online subscription plan, so depends on which plan that you are subscribing for, but you will be entitled to some hours of legal support from lawyers from OLN. Then so it's like just what Cermain said, the agreement is a code one, but like I guess with the input with the lawyers, and then we try to know more about your business, your background, and what you want to do, your purposes. Then we can help to make your agreements like it's more simple for you, and then it's more a life agreement that is like really cater your needs. So I think that's what OLN Online offers.
So yeah, the budget is under control. At the same time, you will be having some coverage from lawyers. And at a point, if you don't think that's enough, you could always reaching out to me or to OLN directly, like the law firm platform. Maybe, for example, when you are having a term sheet, you want someone to review. It's not under the OLN Online direct services under there. But if you are in the OLN Online platform, you could type in, you could see what a term sheet should like, and you think, oh, I still need a little bit more services. Then you can reach out to us. We will be offering services to our OLN Online clients as well, but at a more favorable rate.
Amazing. So if any of our viewers are interested in using the platform to create some of these important documents that we've discussed, you can fill out the form that's listed here on our video or in the chat box, and we'll offer you a discount, 10% discount on the silver subscription to use their platform. So thank you so much, Cermain and Phyllis, for joining
Thank you
us
for having
today.
us.
It's been very enlightening to hear about how co-founders, how entrepreneurs, while they're so excited, can really think about how to strategically and just smartly make sure that all their bases are covered so that they can have a good, healthy startup journey throughout the many years to come.
Thank you for having us. I
Thank
hope
you.
that anyone here can get a little bit takeaway from the conversation we had just now.
Absolutely. Thank you. It was a
Thank
pleasure.
Thank you.
Thank you, everyone.